All right. Good afternoon, everyone, and welcome to Wednesday, April 22nd, as your daily reminder of what day it is, and also today's segment of Family Law Uncorked. I am Jen Bordeaux, the Director of Public Relations with New Direction Family Law, and today I am joined by Joy Alford-Brand. Say hello, Joy.
Hello.
She is a bankruptcy attorney, she practices bankruptcy law. And then I'm also joined with Chris Hicks, one of the attorneys with New Direction. So today we're going to talk about a very light and fun topic that everyone wants to know about, which is bankruptcy. But under normal circumstances, bankruptcy and family law, divorce, separation, all that fun stuff can coincide or intersect. And so now with things, the government and everything surrounding COVID-19, and businesses shutting down, and obviously people's finances being affected, there's questions surrounding bankruptcy related to all of that as well. So that's why I brought in Joy and Chris, so that we can have a fun discussion about all of this and get these questions answered. While you're watching, if you do have questions, please feel free to post them there in the comments, and we'll do our best to get them answered. Otherwise, we will just kick it off. Joy, if you don't mind, just start by introducing yourself and just tell everybody a little bit about you and what you do.
Okay, thanks, Jen. And thanks for having me, first of all. My name is Joy Alford-Brand, like Jen said, and I've been a practicing bankruptcy attorney since 1999 here in the state of North Carolina. And I practiced bankruptcy law for a number of years, and I did other areas of law as well. I was a prosecutor for 4 years. And in 2014, I decided it was time for me to start figuring out another way to help people get their personal finances under control. And so that's when I founded newcashview.com and started writing books and things, and created online courses and webinars and just, different things on that platform to help people who are starting out or starting over. So that's why this is particularly an interesting opportunity for me to be able to talk about that, people who are in transition. So can you hear me okay? Okay, great. So now I lost my train of thought, sorry. I started New Cash View in 2014, but early 2015 really. And since that time, I've sort of been transitioning into this platform as much as possible and away from the active practice of bankruptcy. But I still have bankruptcy clients, and they are still being affected by COVID-19 in this current environment. And so for me, this is a great opportunity to let people know what the challenges are if they're in bankruptcy or if they are contemplating filing bankruptcy, and also divorce.
Yeah.
It's divorce and family, or bankruptcy and family law go hand in hand. Everybody's who's in the legal world kind of knows that. So any questions that you have, I'm happy to answer them.
Awesome. Thank you so much. And I'll say, Joy, we met a few years ago in a networking group that we both used to be part of. And I was there at the beginning whenever you were working on the first book. I don't know if you've had any other publications since then, but knowing you, you have. And I will say that book was it was funny. I mean, your personality absolutely showed through it. And when you're looking at learning how to budget, and Joy, you get so real in the book, and it's funny. And if knowing you outside of that book, I hear your voice when I read it, and it just made me laugh. So when I read it, we'll definitely talk about that more in just a few moments, because I do want people to know what resources you have out there for them. But first, let's start off just very basic, because I will throw myself on the sword. I don't know much about bankruptcy at all. So, but I know the big things we always hear are Chapter 13, Chapter 7. So what's the difference between Chapter 13 and Chapter 7?
Okay, so that's an excellent question. So Chapter 7 is a 100% discharge of your unsecured debt. And I'm going to speak in broad generalities. There are a lot of moving parts with regard to bankruptcy and family law all fitting together, and just bankruptcy on its own. So, these are generalities, just to be clear on that. So Chapter 7 is a 100% discharge of your unsecured debt, and you have to qualify to file. Now, that means you've got to be below a certain income level for your household size in your jurisdiction, and that you haven't filed a bankruptcy or gotten a discharge in the preceding 8 years. So that's the first kind of big, broad brush stroke of Chapter 7. It usually takes about 6 to 12 months if it's a no asset Chapter 7 case. There's nothing to administer for the trustee. After that period of time, you're going to get a discharge order, which is your discharge, and that will turn into an injunction. Tell me if I'm getting too technical here, because a lot of people will be like, what? But so basically, you're going to get an order from the court discharging your debt, which will turn into an injunction that is a permanent bar to any creditor who their debt was discharged in your bankruptcy, proceeding against you to collect the debt in the future. Now, when you file a Chapter 7, you have to list every debt, you have to list every source of income and every asset on your petition. And if you have unprotected equity in one of your assets, then you have to understand that the trustee in a Chapter 7 will sell that, liquidate it, sell that item, and use those funds to pay your unsecured creditors. Okay, so that's a broad brush stroke of a Chapter 7. Now, Chapter 13 is a fundamentally different kind of bankruptcy, and you wind up getting pushed up into a Chapter 13 if you A, make too much money to file a Chapter 7, or B, you have too much unprotected equity that you don't want to liquidate. You don't want a Chapter 7 trustee to liquidate, because a Chapter 13 trustee is not a liquidating trustee. They won't take your property and sell it, but they will require you to pay that equity into your Chapter 13 plan over the life of the plan. And so that means you make a payment to the Chapter 13 trustee for a minimum of 36 to a maximum of 60 months. So that's 3 to 5 years. Those are the basic differences between a 7 and a 13. A 7, you don't make a payment to the trustee. A 13, you do.
Okay.
Not to be too technical.
Yeah. And that's why there are attorneys that practice bankruptcy law that can help us understand this if needed in further detail. And like you said, I mean, speaking in generality, and I would say that's a pretty big staple in our office too, because it depends, right? Is our favorite thing. It depends. Everybody's situation is unique. So absolutely understand that. So keeping in with kind of that broad generality, and Chris, you can probably speak to this too, but so how is divorce affected by bankruptcy? Meaning, does one take precedence over the other? Can a divorce not go through if there's bankruptcy, situation still being decided? How does that work?
Okay, so I kind of think of it in terms of a family law umbrella, right? Because there's more when you're divorcing, when you're talking about divorce, that just talks about dissolving the marriage, right? So there are other issues that are involved there, including domestic support obligations, child support, alimony, post-separation support, and then property division, equitable distribution, etc. And then within the context of bankruptcy, it's also going to be debt management as well. So basically, bankruptcy does not affect your right to get divorced. I mean, that's no court can stand in the way of that. So you can't look to a bankruptcy court to stay that kind of an action. And we should also explain, of course, this might be something Chris wants to talk about, but in order to get divorced in the state of North Carolina, you basically have to file a divorce complaint, which is a lawsuit. And so once that is filed, then it's an open action in court. Well, one of the things that's great about bankruptcies is the automatic stay. And once you file your bankruptcy petition, the automatic stay goes into effect and can stop lawsuits or foreclosure actions or any creditor from proceeding against you to collect the debt. So I want to be very clear that the automatic stay does not stop a divorce action. So once it's filed, it goes forward. The only time really bankruptcy would interfere with any kind of a divorce action or a family law court action would be if, first of all, you're filing as a married couple. Now, this is something you need to think about before you either file for divorce or you file for bankruptcy. And I'm trying to readjust my phraseology here because I'm, could easily speak in legalese. Yeah. But so before you look to get divorced or look to file bankruptcy, you really need to talk to an attorney to find out if it's going to be better for you to file for the divorce first or file for the bankruptcy first. Okay. Because in the state of North Carolina and in general, a married couple can file a joint bankruptcy. So you get two for the price of one. Basically, it's cheaper for two to file together in terms of filing fees and et cetera. Okay. Now, the issue with that is if you are married and your income together pushes you over the Chapter 7 threshold limit, you may want to consider waiting until after you're divorced, because that will suppress your income below the threshold limit to get you both into a 7. Do you see what I'm saying? Mm-hmm. So that would keep you out of a 3 to 5 year Chapter 13 repayment plan with your estranged spouse. So you have to do some pre-filing planning to determine whether or not which one would be better for you to file first. Okay, so that's one thing, filing as a married couple. And the other thing you want to think about is when you're resolving property issues, so equitable distribution. So that's something that, in my opinion, you really need to make sure you're getting good legal counsel. Contact New Direction Family Law here to make sure
shameless plug
you're making the right choice. Because if you have property division issues that you need to sort out, bankruptcy could be a help or a hindrance. It just depends. Does that help?
Yeah, absolutely.
Complicated, but
Chris?
It all is complicated when it comes to. There's a lot of moving parts with family law and bankruptcy.
Yeah.
Right. And so, to be completely candid, if I have a bankruptcy issue, I'm probably going to pick up the phone and call Joy and say, hey, walk me through this. And I don't want my clients to have any misconception about that. If I don't know, I'm going to call somebody who does. But the way I always think about it is, when we're talking bankruptcy, we're talking money issues. So Joy touched on divorce. No court's going to tell you can't get divorced. So, bankruptcy, it's not a shield for your divorce. It's also not a shield for domestic violence. It's not a shield for custody, visitation issues. We're really talking money. Now, she's absolutely right that, there's a lot of finagling and, that goes into, hey, if we're leaning towards separation, should we do this now? Especially if it's amicable, as much as a separation divorce can be amicable, you're going to want to plan for that kind of thing. But really where it comes into play mostly in my world is what debts are being discharged. And I think we'll probably touch on that in a minute. You've got your domestic support obligations that are going to be pretty much untouchable in your bankruptcy. And that's going to be your child support, your alimony, things like that. And that's where it really comes into play. But where it gets tricky then is with the property issues. Yeah.
Right.
Yeah, but that's the perfect segue, Christopher, into
I got my script.
One of the next questions that I had was about those domestic support obligations. So, does bankruptcy, again, in general terms, affect child support, alimony? We've talked about property, so we've kind of already established that, yes, bankruptcy can affect the property division, but what about the child support and or alimony / spousal support?
Okay, so in 2005, we had a whole new slate of bankruptcy legislation passed called Bankruptcy Abuse Prevention, BAPSIPA, Bankruptcy Abuse Prevention Act. And it basically was designed to kind of push people from 7 into a 13 in general. And one major difference before that between 7s and 13s is in a 13, you could get something called a super discharge that would allow you to discharge a much broader spectrum of family law debt, basically. Again, weeding out my legalese terminology here. So in 2005, when the new legislation was passed, then they narrowed down and made very specific the rules regarding domestic debt and financial issues in Title 11, so which is the Bankruptcy Code for folks who are wondering what that is. Want to read it later? Yeah, I'll help you get to sleep maybe. But so the way it works now is, Chris is exactly right. Anything that is a DSO or domestic support obligation is basically untouchable in bankruptcy. In fact, the automatic stay doesn't even apply to it. So that's your child support, your alimony, your custody actions that are filed a lot of times under the same umbrella or the same complaint as a divorce action. However, with regard to an equitable distribution action, the automatic stay does go into effect, and state court judges are schooled on this, so they're aware of it, but the automatic stay goes into effect, and the only delay that you could foresee, unless there is an argument about class of asset or something of that nature, is counsel filing a motion to lift the automatic stay in state court in order to move forward with the equitable distribution action. So once the automatic stay goes into effect, it's just a very routine matter that counsel for the creditor spouse, which is the non-filing bankruptcy spouse, right, would then, sort that out, get the motion filed, and then have that order entered lifting the stay. At that point, state court can go ahead and proceed with the ED action as they normally would. Now, of course, there could be issues about arguments with dischargeability on assets and et cetera, that you could potentially see in bankruptcy court. That's a possibility, but that's a very technical and in-depth discussion you should have with your attorney just to see if that's going to be an issue for you. So that's the state court side. And it's something that, in my experience, bankruptcy courts have been very wary of getting involved in state court issues. They're gonna say, nope, that's a state court issue. That's where you need to handle it. So they're usually pretty good about moving forward with that. Now, on the bankruptcy side, there is a substantial difference between ED actions and how they're treated in Chapter 7s versus Chapter 13s. So in a Chapter 13, all or a part of the equitable distribution debt may be dischargeable depending on maybe you're filing a 0% plan, et cetera. Let me explain. Let me back up a little bit. So it's very technical, very complicated. But in a Chapter 7, when someone files a Chapter 7, they're basically saying, I don't have enough money to pay my unsecured creditors. Unsecured creditors are credit cards, most medical debt, things like that, right? Personal signature loans, et cetera. Now, in a Chapter 13, what happens is that's called a wage earner's bankruptcy. So you make enough money that you can pay a material or, substantial dividend to your unsecured creditors, right? And that is something that's laid out in your Chapter 13 plan that the court confirms. And that's how you basically are told you're going to proceed through your Chapter 13, what kind of plan payments you're going to make, and et cetera. So in a Chapter 13, the equitable distribution, the creditor spouse is basically considered an unsecured creditor. Okay. So they are lumped in with the rest of the unsecured creditors. And so therefore they will get the same distribution as the other unsecured creditors, generally speaking. Okay. Now it is possible that folks who may not qualify for Chapter 7 for whatever reason might file something in Chapter 13 called a 0% plan. And that could be 0% distribution to unsecured creditors. So that's something just to be aware of, okay? So in Chapter 13, you could potentially discharge a major portion of your ED debt to the non-filing spouse, right? And then once you've made all of your plan payments, that discharge order becomes an injunction, just like it would in a Chapter 7. Does that make sense?
Yeah.
Complicated.
It just reiterates the fact how in these scenarios you would want both a family law attorney and a bankruptcy attorney.
Yep.
Just for layman's terms, just want to, because you mentioned ED again, and I just want to say that ED is the same thing as equitable distribution.
Right, property division, right.
Yeah. And then whenever you say, there's a stay on the case, just in very simple terms, just means that keeps it from proceeding in family law court because of the bankruptcy. Is that correct?
Well, yes, the automatic stay is imposed in federal court, but it covers any, creditor or action against you to proceed to collect the debt.
Gotcha. Okay. Chris, anything to add to that?
No. And more.
Okay. So now looking at, that's kind of our baseline about our very quick and dirty about bankruptcy and family law. So, and obviously it is much more complicated than what you just communicated, but reading between the lines. So now looking specifically at what we are facing now with COVID-19, the public health crisis, and the far-reaching effects of this, and obviously there has been government response in a few different ways. How is this currently affecting bankruptcy or payments that are supposed to be made and creditors and all of that good stuff?
Such a good question. I actually was dealing with this last week. So this is all very, very new. And I want to preface all my comments about COVID-19 and the CARES Act, because that's where bankruptcy has largely been affected. The Families First Act didn't have any bankruptcy language in it, but the CARES Act that was just recently passed, that's where all of this is coming from. And it's, my comments here are largely anecdotal because this is all still really new, okay? But one way that traditionally Chapter 13s have been managing this, because that's what we're talking about here. We're not talking about Chapter 7s. There's no payments to a trustee in a Chapter 7. So Chapter 13s, the way we've managed substantial change in circumstance and tried to address changes that are needed to the plan and the plan payments is through a motion to modify. And that's something that has always been around. It's something that attorneys have commonly used to help their clients adjust their circumstances in the bankruptcy plan for those purposes. And that is largely how things are moving forward with this coronavirus situation. So in terms of whether or not you can miss payments or et cetera, or waive payments, then technically my answer to that would be no more than in any other motion to modify. But what you could do is, and I filed mostly in the Middle District, which is Durham and that area. I am admitted in the Eastern District, which is Raleigh and, East. The only district I'm not admitted in is the Western District. So mostly the trustees in the Middle District are great. And they are, if you have a big issue with your income or you've had surgery or something like that, they've in the past said, no problem, we'll waive a payment, or we'll try to, adjust your plan to absorb that, because you still have to comply with the terms of your plan, And so they've been great about that. But you could certainly ask for a waiver of a planned payment in your Chapter 13 plan. But, a lot of times a trustee will just go ahead and say, as long as it's a minimal length of time, they'll waive it without having to go to court. But the CARES Act has done something unusual and extended Chapter 13 plans by 24 months. So if you have been in any way affected by COVID-19, then you can tack on another 2 years, yay, to your Chapter 13 plan, right? And what that's going to do, and of course, I'm speaking anecdotally because this is all really new. And what that does is it lengthens the amount of time that you're in your Chapter 13 repayment plan. So you're going, way over what you would traditionally have had access to. And so as long as that's not increasing the distribution amount to your unsecured creditors, then that is going to lower your payment. So there are two ways that you could potentially work on keeping your client alive if you're a bankruptcy attorney in their Chapter 13 plan. One is to ask for maybe a waiver of payments for a month or 2 or 3. And the other one is understanding that you have that now 24-month extension that you can file a motion to modify and ask for to help them keep that Chapter 13 alive. So to my knowledge, that's where we're at right now with this COVID-19 situation and Chapter 13 plans.
Gotcha. Chris, any questions from you? I feel like, do you feel like you're getting a bankruptcy CLE right now?
I'm sorry. It's so complicated, but it's
without the credit. Well, Joy, one question I do have is, we're having major shutdowns with courts. I know bankruptcy is a lot of electronic filing anyway. Are you guys seeing any delays in, bankruptcy court actions or rulings or anything?
No. So here in North Carolina, we have been filing electronically for years. Mm-hmm. So, when I first started, and I'm going to give away my age a little, when I first started, I used to have to mail my petitions to the clerk of court's office in Greensboro with a self-addressed stamped envelope so they could mail them back, and they would come with a sticker on them and all that stuff. But now I can file a bankruptcy at any time of the day or night with my laptop. So there's no issue. And one of the things I have always loved about being a bankruptcy attorney here in North Carolina is the court functions in a timely manner. The judges are excellent practitioners of the law, and they are very timely. Things don't hang around with them. They get things moving pretty quickly, and they know what they're doing. And so we're very, very lucky to have an excellent debtors bar and creditors bar here, and judges. So we've been filing electronically for a long time, and the court was quick to adjust. So they're doing hearings telephonically. I really haven't seen any delay in deadlines of filings or anything. There may have been a short delay initially just to transition into this new environment and way of working. But aside from that, no, it's been working great. So I understand there's some difficulty with state courts that electronic filing is still kind of new. So, but no, in federal courts, at least in the bankruptcy court, I couldn't say otherwise, but in the bankruptcy court, where things are moving along pretty quickly.
Okay.
Well, the state court, electronic filing it's just still a dream at this point, isn't it, for North Carolina? Like,
I really haven't done a lot of, aside from, their odd speeding ticket for a friend and et cetera, recently. I haven't been in state court in a while, so I couldn't say.
It's a beautiful dream.
Yeah. Yeah, definitely. Well, we don't have any questions live. We have had several viewers, which is awesome. Hopefully they're all learning some very valuable information. But Joy, tell us a little bit about New Cash View, because you mentioned that whenever you were, your little intro at the beginning of this, and how you switched to helping people budget, so maybe bankruptcy wouldn't become an issue beyond the front end of things. So talk a little bit about that and those resources and how people can find out more about that.
Well, so the whole thing got started, I was actually in bankruptcy court at 341 meetings. So when you file bankruptcy, you have to attend a 341 meeting. And the reason it's called that is because that's the section of the Bankruptcy Code that mandates it. And so I was sitting there and I had filed a bankruptcy. I was waiting for my client's case to be called. I'd filed a bankruptcy some 10 years prior, and I heard a name called and I looked around and it was those people, and I'm sitting there thinking to myself, of course, having no idea what their circumstances are, because there's legitimate reasons people would need to repeat file. Okay. But I had a moment where I thought, wow, I didn't help them. Here they are. I filed for them in, 2007. And here I am in 2014 or whatever. It was like 10 years, give or take. So that would be 2004. Here it is, 2014, and they're filing again. And I had just a moment where I thought, I've got to find a better way to help people. And I have a lot of experience having done bankruptcy work since 1999. And my parents filed bankruptcy and got divorced when I was a kid. So this is a very personal thing for me. So I decided it's time for me to figure something else out. And so I sat down and I wrote Money Basics, Keeping It and Growing It, What I Learned About Money as a Bankruptcy Attorney. Never one to shorten the words of the title there. And so I got really good response from that. And then I decided what I really know at the end of the day is how to manage debt. So I thought, maybe I could make some type of online course teaching people how to manage their debt and credit, basically. So I created a 4-hour online course called Credit 101, your credit and you, basically, Credit Management 101. And you can take it, you can purchase it, take it, you have it for life. And it's a video-based course that teaches you all about your credit report, your credit score, how to manage your debt, and other miscellaneous things like bankruptcy and et cetera. And then from there, I created a budgeting class. And recently I wrote a Parent's Guide to Better Borrowing, teaching parents and high school students how to make better decisions about student loan debt, because before the coronavirus hit, that was becoming a big issue. You could see it playing out all over the news. Mm-hmm. And our student loan debt is just creeping up and up and up. And of course, largely not dischargeable in bankruptcy. There are slim exceptions to that. We could talk about that if you wanted, but probably not. So I decided, well, I'm going to create some webinars teaching people who are college students or college graduates about their student loan debt and how to manage it, and also parents and high school students. So those are right now my online programs. I'm also working on a course based on my book, Money Basics, but that I have to change up now because of this whole coronavirus situation. It's just been crazy. So aside from that, folks can find me at my website, newcashview.com. They can sign up for my weekly newsletter, The Joy of Money Management, or you can check out my free, I do a lot of free content. You can check out my YouTube channel, NCV TV, to see me talk about all things personal finance. And I also write a blog called The Dollar Llama that comes out every month. And, you know, I'm out there having such a good time on the interwebs that, you know, help just doing everything I can to try to teach people how to make better personal finance decisions and just basically teach financial literacy. So yeah, that's in a nutshell.
Which is awesome. And I'll say, you know, I follow you on Instagram and see you on Facebook and stuff too. And these videos that she does are not just her sitting there. Like if it's around a holiday or something, there's going to be something for your for your viewing pleasure, a costume, a character in the background, whatever it is. So well, entertaining and educational.
Well, I will say that it is kind of hard to make jokes right now because of everything that's going on. I've had a hard time with that, but I've had to be so serious as a lawyer my whole career that now if it's going to make somebody pay attention to me, I will totally put on a sombrero and juggle bananas to get my message out there, you know? So, but right now I'm toning that part down just because this is such a horrific situation. So,
yeah.
But thank you for that. Appreciate it.
Yeah. Chris, are you going to start wearing a sombrero and juggling bananas in the office?
Well, I mean, I was just thinking we've been struggling with that too. I mean, we like to have fun, and, you know, my clients will tell you, I joke around a lot, but it is tough right now, you know. Even people who really haven't been personally affected, you know, with loved ones, you know, getting infected, you know, it's tough on everybody. So, you know, it is hard to kind of have that fun with your job right now, especially this job.
Yeah.
Yep.
Yeah.
But I will put on a sombrero. Don't put it when it's up, you know.
I can't wait for that. Pictures will be taken. Social media will be filled with them. I can't wait. Joy, thank you so much for joining us, because I think this is something, while it may not be, you know, like we've said, the most fun or comical topic, it is very important. And it's just another way, it just shows another way that the, you know, current pandemic is affecting things, and how so much of this can be woven together and affects so many people on such a broad level. So I really appreciate it. And then COVID-19 removed our clients, period. And me personally, with whenever you're going through separation and you're going from 2 incomes to 1, you know, to manage households, budgeting is a huge piece of that. And I know, and Chris can speak to this a lot more than I can. He works day in and day out with the clients, but realizing now how to adjust to that and really focus on that budget to prevent, you know, or because, you know, if you're going to take on some of this marital debt too, because that gets split just like the assets do. Yep. You know, you got to figure out how to deal with all of that and then manage it with the income this new income situation you've got going on. So huge tip, resource for people. And I hope that they take advantage of it, and we will absolutely, whenever we recognize a need, we know who to send them to. So thank you on your personal mission and journey to help people with their personal finances and figuring all of that out. Thank you for taking time to join us today and share your knowledge and experience. Chris, thank you as well for joining. I hope you've learned something as well today.
Thank you so much for having me. I appreciate it.
Yeah, absolutely. You guys stay safe and healthy out there, and we'll see you next time.
Thanks.
Yeah.
Bye-bye.